Town at 00:47 hours, and that is on the 24th of June, the same night, at Kilemambogo at 1:27 a.m. to 1:23 to 1:27 a.m., at Mlolongo at 6:02 a.m. to 2:53 p.m. Now, PW36 testified that the police pocket phone, IMEA number 8641060-200-198-73, which was Exhibit 25. On the 23rd of June 2017, the said pocket phone was captured in various sites of interest as per its data, which was Exhibit 79. It was located at Mavoko locals at between 12 and 12:20 hours, at Syokimau AP post between 12:20 and 12:40 hours, at Mombasa Road between 13:40 and 14:40, at Mlolongo Police Station 15:20 to 15:40, between 18:40 to 1900 hours, it was at Syokimau AP post. Then between 1900 to 1920 hours, it was captured along Mombasa Road. At 1940 hours, it was at the isolated area in Soweto, where it was stationary for 5 hours. At about midnight, the pocket phone was sighted at the southern bypass on the way to Thika Road. PW36 stated that the radio in question was recovered from the first accused when he was arrested on the 1st of July 2016. That trajectory of the phone, which was Exhibit 79, is in tandem with the retracted confession of the fifth accused in every respect. It shows that the first accused was present in those sites as shown herein above, as the fifth accused stated in the retracted confession. Now, the other evidence which speaks to what is contained in the confession of the fifth accused is the evidence of PW 10, 11, and 12, residents of Soweto isolated area. From their evidence, they confirmed sighting one, then later two vehicles parked within the vast isolated area. Their evidence confirms that the persons they saw standing around the vehicles were 4. They saw one with a police phone and one smoking a cigarette, that they remained in that area from around 7 p.m. way past 11 p.m. that night, that they identified themselves as police officers, and all these details were in tandem with the confession by the fifth accused. The retrieval of the bodies of the deceased on the 30th of June and 1st of July 2016 from the River Adi, 7 days after the murder in respect of the first and third deceased, and 8 days in respect of the second deceased, all confirmed the retracted confession of the fifth accused that he was telling the truth concerning the entire process. The postmortem findings confirmed that the fifth accused, what the fifth accused said, that the deceased were murdered. Now, the evidence on the data that is Exhibit 79, which was from the radio, Exhibit 25, the evidence on the note, Exhibit 10, the note, I think was Exhibit 7, the evidence of PW 10, 11, and 12, the evidence of PW 20, the OCS, and the evidence of the retrieval of the bodies of the deceased from the eyes of independent evidence. That evidence was consistent with the retracted confession of the fifth accused and confirms that what was stated in the confession was the truth. Furthermore, the note Exhibit 7 collected outside the container used as a cell at the post bearing the handwritings of the first deceased are proof beyond any reasonable doubt that the first deceased had been taken to the post on the 23rd of June 2016 in the afternoon, as the fifth accused stated. The other evidence was a vehicle KBX 126C, which ferried the deceased to the Mavoko locals, which was recovered in Kameredu, just as described by the fifth accused. The fifth accused DNA from the cigarette butts recovered at the Soweto open field where the murders took place. I have carefully considered the retracted confession and the other evidence, as well as I cautioned myself of the danger of relying on the retracted confession of the fifth accused, Exhibit 90, having considered all the circumstances of the case and bearing in mind the independent evidence as enumerated herein above, which I found to be consistent with the retracted confession of the fifth accused, I'm satisfied that the fifth accused stated what the fifth accused stated in his retracted evidence was the truth and details what happened in this case. The retracted confession stated clearly the plot and the plan to murder, the different roles played by the various actors, to ensure seamless execution of their plan and murder of the deceased and the disposal of the bodies of the deceased 100 kilometers or more from the scene of murder. I'm satisfied that taking all the evidence and the surrounding circumstances of the case into consideration, that there is no reason to believe that the retracted confession by the fifth accused is not. Sorry. I'm satisfied taking all the evidence and the surrounding circumstances of the case into consideration that there is no reason to believe the retracted confession by the fifth accused is not the truth of how the deceased met their death on the material day. I must at this juncture set out the fifth accused's own statement in his defense in court, the difference between the sworn defense and the retracted confession. In his sworn defense, the fifth accused maintains the structure of his story in the retracted confession, but drops some names and brings in new names into the conspiracy of the murders and the execution of the deceased persons, as well as varies the role he played in the murders. He stated that when he realized that PW 20 Chief Inspector Lelei was in Mlolongo Police Station, he started going there to sell jeans, which is what he did for a living. That he did so on the 22nd of June 2016, and that on the 23rd June 2016, very early in the morning, he received a call from PW 26 PC Wilson Kamau asking him to report to Mlolongo Police Station that morning, which he did and was there by 8:30 a.m. He said that he found PW6 with one Waingo and one Kamenjo, both police officers, that PW26 told him that there was a Kamwizi, a thief, that he was due to go to court for his trial that same day, and that he wanted to eliminate him, and that his role, that is the role of the fifth accused, was to keep track of the man and keep reporting to Kamau. That at the same time, PW26 gave him a phone number to use while calling him, saying his had gone off, and of that number, he could only recall 0786. He also changed the story, saying it was PW26 who called him to describe how the man he was to track was dressed. The other variation he makes in his sworn defense is that the Toyota NZE was with one Brown and not Kamenjo, as he had stated in his confession. Kamenjo was also there, and that he was the one who handed over to him the vehicle that the deceased left the court in. He varies his story, saying that he was directed by PW26 to take the vehicle of the deceased person and a small walkie-talkie to a police officer in Kamerudo, at Kamerudo in Limuru. He also changes his involvement, saying that he was left at a bar when PW6, Kamenjo, Waingo, and Brown went away with one Mwaneki, a police officer, to the post where the deceased were held. He said that Waingo found him at the bar at 9 p.m. and told him where to go to find PW26. That was the Soweto area. He gives the names of those he met at Soweto, open field, as PW26, Kamenjo, and Brown, who were standing together, while a distance away stood Mwaneki and Wawero. Then Waingo joined them at 10. He gives the role he played as that of sitting inside the vehicle and driving one of the two cars. He also said that before they drove to Thika from that scene, the first accused brought money to PW26 to fuel the vehicle, he, that is PW26, was driving as it was a station vehicle. The other detail he added was that after their return from Thika and the bridge at Oldonyo Sapuk, where they dumped the bodies, Leliman came to the bar where he, Kamenjo and Brown were waiting for others and brought them 5 kilos of roast meat and 5 bottles of beer each to enjoy. He said that the bar belonged to the first accused and that the wife of the first accused was the cashier. Now, the name that was dropped in the fifth accused's sworn defense was that of Sergeant Mwangi, the fourth accused in this case. The confession had mentioned PW26. However, in his sworn defense, the fifth accused said that PW26 was the mastermind of the execution of the deceased and that he was the one who approached him for his assistance in the plot to murder the deceased. The fifth accused added new names, Mr. Brown, Waingo, and Mwaneki. He also decanted the role of the first accused from being the mastermind and planner of the murders to being a facilitator and an entertainer. Now, having considered the confession and the sworn defense, I find that the structure and the main features of the information the fifth accused gave in both these statements remained intact, and therefore it does not make any material difference or create any doubt as to the fact the incidents discussed in the statements took place. Now, both the retracted statement, Exhibit 90, and the sworn defense qualify as a confession, and this is because, based on the confessions without other evidence, there is sufficient evidence to sustain a conviction against the fifth accused. As to the probative value of the confessions, of the confession Exhibit 90, on the co-accused, I will discuss it here in subsequent paragraphs. Now, I've also discussed the lock-in co. The prosecution had built up its case around 5 scenes. The lock-in co that featured prominently in the evidence of the witnesses in the case. In addition to these scenes, it emerged that there were underlying factors that formed in an integral way the background events that were the catalyst to the sequence of the events of 23rd of June 2016, leading up to the murder of the deceased. I have herein above dealt with some of the underlying factors. I'll deal with the issues identified for consideration as above, as well as cluster the various lock-in co in as much of a chronological order as will be practical to determine whether the prosecution has discharged its burden to prove its case against the accused persons beyond any reasonable doubt. So the first lock-in co is Mavoko locals, where the first and the second deceased and PW1 and a colleague of PW1 had gone for the case against the second deceased, and it is from there that they were abducted as they after leaving the court. Then we have the other lockers in co was Camiredo. This is where the fifth accused took the vehicle that had ferried the deceased persons to Mavoko locals. Then there was Syokimau administration camp. So the prosecution is that the 3 deceased were held at the post between midday of 23rd of June 2016 and the 18:59 hours when they were removed from there and taken to Soweto open field. PW2 and 3 were the witnesses under Witness Protection Agency. They were cousins who had worked at the construction site in Mlolongo area. They gave similar and corroborative evidence. They stated that on the 23rd of June, at about 1600 hours, they were coming from work together with PW2 riding a motorcycle and PW3 as his pillion passenger. On getting to the chief's camp at Syokimau, they both heard the voice of someone calling them in a low tone, which sounded more like whistling. They stated that the person was beckoning them and appeared as if he was hanging on one hand on a window grill inside a container. And because of that, none of them could fully see him. So the evidence is that he threw the note, which is the subject matter of the case, and urged the two of them in Kiswahili, piga hiyo namba, mwambie aje sahihi. That is, call that number and tell her to come here right away. So they stated out they rode to the nearby market so as to read the note, and the efforts that they made to reach to the wife of the second disease, that is PW4, and the way that she reacted. She was she was difficult. Eventually, IJM got to know that information from the same lady, PW4, when the second disease did not go home. So she panicked and informed IJM, and then how they swung into action. Now, an issue had been raised about the note by the defense. And also the involvement of PW6, but I have said in the case, first of all, the note was started. It was only held together by lamination, which was put by PW44 and PW45. Now, PW6, who was being objected to as having participated in the investigations, was actually an investigator with IPOA and was the initial investigating officer investigating the complaint by the second disease, and therefore I said there was nothing untoward about his involvement in the matter, even the taking of the note from the PW2 and 3 and IJM. Now the note was also examined. The evidence of PW8 is on record. It confirmed that the note was written in the hand of the first deceased. The known writings of the first deceased were given together with those of the second and third deceased that IJM had, and it confirmed that it had been written in the hand of the first deceased. Now, there was also the evidence of PW4, Corporal Joseph Muchero, who visited the post on the 24th of June 2016. And he told the court that his duties were to conduct investigations upon instructions by the officer in charge, investigation branch. He says on 25th of June, he was instructed to join Chief Inspector Wino and Inspector Chemelin and conduct investigations relating to the disappearance of 3 Kenyans. He confirmed that he went to the post and carried out measurements in hand with PW39, and the conclusion was that it was possible for a socket to have been thrown through the grills of the cell at the posts, and also that there was no way somebody working at the report office could not have seen people held inside the cell at the post. Now, the second and the third accused who were the officer in charge of duty and the officer manning the report office and the sales sentry on the day in question, that is 23rd of June, deny receiving any persons to the post on that material day. So the second accused in his unsworn defense reiterated that the post had no cell, only a report office and a store. He said that he was at the post from 12:30 hours to 1800 hours when he left from Lolongo police station until 2000 hours when he returned to the post. The third accused on her part emphasized not being at the post between 1100 hours and 12:30 hours, and afterwards from 1800 hours. However, from the evidence of the crime scene officers, I find that if the prosecution establishes that the three deceased persons were taken to the cells on the 23rd of June, the third accused who was on duty as cell sentry and report office personnel saw them and therefore knew of their presence at the post. Now, Mr. Keegan for the third accused and Mr. Muchere for the fourth accused took issue with the note. I think I've already talked about the note, urging that this PW2 testified that he threw it away when the PW4 disbelieved his message. I've said the state of that note and the finding by the document examiner. I don't need to repeat. Now, the Soweto open field, now PW10 was a daughter to the registered owner of a vast 90-acre piece of land situated along Mombasa Road opposite Mastermind cell site. She stated that the place where the land is situated is popularly known as Soweto and is situated on the right side facing Mombasa direction along Mombasa Road near the Nation newspaper facilities. She stated that on the 23rd June at around 7:30, she decided to escort her visitors from her home to the road, and on the way back, she said that she noticed that a stationary vehicle which had stopped on the road near the entrance to their land and had its full lights on. She further stated that the vehicle had its hazard lights on, and from a distance, she was able to make out three heads of people standing outside the vehicle, but could not hear their conversation. She says she sent her brother, who was PW11, to go and investigate for her, accompanied by PW12, who was a PC Matambo, a police officer, at the Way Bridge. And what they discovered is that the people told them they were police officers and that they were on duty. Now, the other lockers in pool was the Oldonyo Sapu, Kilimambogo. And here I said that there is no argument about this site. This is where the bodies of the deceased were flung into the river Athi past midnight, that is on the 23rd and 24th June 2016. The bodies were retrieved from the river on the 30th of June and 1st of July 2016. Then there was the technological evidence. I stated at the beginning of the judgment, there was no witness account of the murders of the three deceased. The prosecution has relied on circumstantial evidence, forensic evidence, and the retracted confessions made by the fifth accused person. This evidence that the prosecution has relied upon includes technical evidence made up of phone data processed and produced by PW42 from Safaricom and 43 from Airtel. There were various call sites captured in the data involving various mobile phones. So the information required of the Safaricom and Airtel service providers was handset history, cell data, subscriber registration, and geographical location from 20th of June to 26th of June 2016. That means the information provided by PW42 and PW43 from the phone service providers to PW44 and 45 and their colleague investigators was capable of providing the history of the handset in question, showing when bought and which SIM cards had been paired with it. With the cell data, one could see the phone calls made or received through the number, as well as the time and duration of the call, It also gave details of SMSs sent or received through that line, and gave detail, the subscriber details, gave details of the person registered as the owner of the line, and if registered more than once, the details and the data of each registered owner. The geographical location gave detail of the actual location of the cell phone number or handset, and that trajectory of that record could show the movement of both the handset and the cell phone number. The only time it could not be possible to be tracked is if the phone was turned off, and this was according to the evidence of PW 42 and 43. Now, as stated earlier, PW 44, the Inspector Olesena, and PW 45, Chief Inspector Mwangi, they were part of a team of investigating officers of this case, and the two are the ones who ultimately compiled the investigation file. Their evidence as well as their witness statements were largely similar. Now, PW 44 stated that on the 19th of July, he wrote to Safaricom for the signature of PW 28, and he asked for certain he was asking for data. He requested to be provided with all the numbers that were captured by the following cell site masks between 900 hours of the 23rd of June 2016 and 600 hours of 24th of June 2016, and those are Siokimau, Esa, Adriva, Kamiridu, Mastermind, and Kilimambogo. On the 4th of August, he wrote again to Airtel. He was requesting for data and subscriber details. Before I go there, PW 44 stated that from the information available to him, the number 0727-433-431 was traceable at all the 5 sites that were of interest. PW 44 stated that he first searched the subscriber number in all the social media platforms. Upon searching in Truecaller, the name recorded against that number was only one name, Brown. He further searched on the Facebook and found a picture and the name Peter Nguge. The picture was produced here in court as Exhibit 108. It is the very image of the 5th accused. Now, PW 44 testified that on the Facebook, he found friends of Peter Nguge, some of whom were police officers at Mlolongo Police Station, and one such officer was Wilson Kamau, who testified as PW 26. Now, PW 44 testified that on the 4th of August 2016, he wrote to Safaricom requesting subscriber details for the number of the 5th accused, and the details showed that the number belonged to one Peter Nguge, the 5th accused in this case, and this was the same person he recognized by the Facebook picture. On the 4th of August 2021, PW 44 wrote again to Airtel requesting for other numbers. Now, one of those numbers, the number, he says that there was a number 0786-526-465 was captured at Adriva, Mastermind, Kilimambogo, Siokimau, and Thika Road, and that number was in constant communication with the number of the 5th accused, and that number 0786-526-465 was used in IMEA number, which is a long number, the two of them. Now, that IMEA belonged to PW 22, that is Corporal Nyakundi of Mlolongo Police Station. So PW 22, Corporal Nyakundi testified that on the 23rd of June 2016, at around 900 hours, while at Mavoko or Locos, he was approached by one Mr. Brown. He testified that the first accused had introduced Mr. Brown to him at Mlolongo Police Station canteen on 2 occasions in the month of June 2016, saying that he was an administration police officer. He said that when Mr. Brown requested for his phone on the 23rd at Mavoko Locals, he could, so that he could make a call, being an acquaintance and being in a hurry, he removed his SIM card from his number 0734426104 from one of his handsets, which was Exhibit 38, and handed over the handset to Mr. Brown. He said that his mobile phone handset was a Samsung and gave the IMEA number. Now, through the IMEA handset, PW44 established from the data that the number inserted when PW22 gave the phone to Mr. Brown was 0724. It was 254-786-307473. That number was used in the answer to communicate 15 times. 10 of the times was through SMSs, while the remaining 5 were voice calls. Of importance is that the number was in constant communication with the number of the 5th accused, as well as another number which was 0786-526-645, registered in the name of Moses Kareidi, who was PW39. Now, PW39 denied that he ever had such a number. He gave his numbers to court and testified that in January 2016 he had lost his identity card number, his identity card within Mlolongo, and that he had reported the matter to Mlolongo Police Station. Now, the 2 numbers, that is the 2 that were in constant communication with the number of Mr. Brown. So there was the one registered in the name of Moses Kareidi, while the other one was registered in the name of Charles Nyaberi. Of importance is that the 2 numbers were registered on the same day, that is 1 day before the murder of the deceased, that is on the 22nd of June 2016, and it was between 1800 and 18, that is between 6 and 609, meaning that it was registered 9 minutes apart from each other and registered with the same agent within Mlolongo area. So from the findings of the analysis, the 5th accused person inserted a SIM card for numbers 0786307473, and that line was in constant communication with the number of the 5th accused, and then the other number 0786526645. This was while the 5th accused was at Mavoko Locals until the 3 deceased were kidnapped and taken to the post, and also while the 5th accused drove KBX 126C to Cameredo. That means the 5th accused continued using his personal line, and therefore the 2 other numbers used by the others who were part of the team that executed the deceased. I have said that these 2 numbers are not mysterious. They must be among those. These 2 persons who had those 2 numbers are not mysterious. They must have been among those names the 5th accused has given to the court in his confession and in his own defense, without singling out for us to know which of them had that number. Now, the other line analyzed by PW44 was 0716876388, registered in the name under Bird's Eye Auto Truck. Now, that number was fitted in the vehicle that delivered the deceased persons to Mavoko, and therefore I do not need to read any further. Now, the analysis received by the numbers received by PW44 also was for the deceased persons, and they just confirmed they were switched off immediately after the kidnap. That is what the data was showing. Now the next issue to consider is the one of the phone data for the first and the fourth accused. Now, PW 44 testified that the phone data of Frederick Leniman, the first accused herein, number 0722939198, and of Leonard Mwangi Maina, the fourth accused, herein were not spotted along the scenes of interest at the timings in question. The first accused data exhibit 98B shows that he was away from the geographical location of Mlolongo. Indeed, the fourth accused gave an elaborate defense of how his movement on the 22nd and 23rd, backed up by 4 witnesses. That is defense witness number 6, defense witness number 9, and number 11. So he was away from Lolongo, and those witnesses testified they were together in Ruiro and also in Thika. Now, the phone data of the first accused, Exhibit 9D, showed that the first part of the day, the first accused was en route from Mlolongo. However, at around 1300, that is 1 p.m., the data spots him at Mlolongo police station. At around 1351 to 1554, the phone was at Mlolongo Valley, where he was resident. At 16:35 hours, it is captured at Mlolongo. At around 1723, at Center Mombasa Road up to around 1839, and that at 1855, the first accused phone is captured at Mlolongo police station. At 2026, his phone is captured at Mlolongo Gwata, and around 2150 at Mlolongo police station, and finally Mlolongo Valley at around 2001. So the phone data of the first and the fourth accused places them away from the relevant sites where the conspirators swung into action to take the appropriate actions against, which culminated with the murder of the deceased person. In addition, as shown on the part of the fourth accused, he put forward alibi defense and called witnesses who corroborated his evidence, effectively shaking the veracity of the evidence of the fifth accused confession against him, which was the only other evidence against him. As for the first accused, there was other evidence against him, as will be shown in the judgment. Now, the phone data of the second and the third accused, Mr. Mbeta for the second accused submitted that the phone data of the second accused supported his defense of the times he was not at the post, which is the time the deceased were brought and later taken away from the post. Now, Mr. Keegan for the third accused submitted that the third accused played no role, was not mentioned in the confession of the fifth accused, and that all that her phone data established was that she was in the locations claimed, but that that did not connect her to the offenses. He also urged that PW18 in his evidence confirmed that the third accused left the post at 18:30 hours. Mr. Keegan urged in the alternative that the court should consider the police pecking order and find that the third accused person, being a junior officer, had to obey orders. Now, PW44 presented the phone data for the line 0720-388-784, registered in the name of Stephen Cheburet Morogo, who is the second accused in this case. He testified that the phone data for the second accused, Exhibit 100B, shows that on the 23rd of June 2016, at 6:19 hours, he was at Syokimau Kiunguni, which is within the AP post. At around 8:42 hours, his phone was at Mlolongo police station. This is around the same time that the fifth accused also arrived at that station from Waidaka. At 9:24 hours, the signal locates the second accused phone at Esa at the river, which covers Mavoko locals. PW44 say that that was also the same time the fifth accused arrived at the locals' premises. At around 10:40 hours to 10:48, the second accused phone is located at the river Transview, which is where the railway line, the site of the kidnapping, is located. At 11:13 and 12:01, the signal is along Mombasa Road. whereas at 12:10 it is at Caltex depot. At 12 hours, that is 2 minutes later, is back to Syokimau AP post and remains there up to 18:49 without leaving. So the time of 12:12 is crucial because it was around the same time that the deceased persons were transported to the post and placed in the cells and kept there until the evening. So between 1830 hours and 1900 hours, the deceased were taken from the post to Soweto open field, which was the murder scene. Now PW 44 stated that around 1851 hours, the second accused phone signal was recorded at Caltex depot, and 9 minutes later at Mastermind's Mombasa Road. At around 1906, PW 44 testified that the second accused phone was captured at Mlolongo police station, where he stayed up to around 20:02 hours before going back to Mastermind, the Soweto open area, field area. At around 22:20, the second accused phone went off since no further data was collected. Now PW4 testified that number 0719644520 was registered under Sylvia Wanjohi, who is the third accused in this case. Our phone data, Exhibit 97B, shows that on the 22nd of June 2016, she was at Mlolongo until 20:05 hours when she returned to the Syokimau AP camp. PW 44 testified that on the 23rd of June 2016, the phone data of the third accused reveals that she was within the camp or the post from 10:01 hours, that is 10:09 a.m. in the morning, to 22:31 hours. So between 22:31 hours on the 23rd of June and the morning of 24th of June 2016, there was no data generated from her phone, which meant that the phone was switched off. So PW 44 stated that it meant that the third accused was stationed at the camp throughout the day of the 23rd of June 2016 and never left the station between 10:09 hours and 20:31 hours. Now, given the circumstantial evidence adduced against the second and the third accused, what was required of them in law is an explanation to rebut the statutory presumption created by virtue of the fact their phone data placed them in all the lock in quo as described in respect of the second accused and in the post at all the relevant time in respect of the third accused. Now the second and the third accused do not deny that the phone numbers were theirs. That means that what happened at the post in respect of the third accused and what happened in the lock-in quo in respect of the second accused was within their knowledge, and that it was in their best interest to offer a reasonable and plausible explanation in that regard. That is what is Section 111, subsection 1 of the Evidence Act requires of them, that they have a statutory burden to give an explanation to rebut the statutory presumption created by the circumstantial evidence that they were involved in the murders. Now, the data on the phone of the second accused, who was defense witness number 1, Exhibit 100B, contradicts his testimony of where he spent the day. The second accused did not deny having his phone and using it on the 23rd of June 2016. His testimony was that he left the post at 600 hours for Athi River for personal matters, which he completed doing at 9:50 hours. He then testified that he proceeded to City Cabanas, an area covered by Caltex Mombasa Road, Mast, where he met the second accused for purposes of viewing a cooker at Rampton Supermarket. He said that they returned to the post and that he was there from midday to 600 to 1800 hours. The third accused in her own defense told the court that she went with the second accused person to City Cabanas on the 23rd of June. She stated that she spoke with the PW18 to hold her fort. She then said that she left for Cabanas at 1100 hours and reached there at 11:30 hours. She says she returned to the post at 12:30 hours, and she then said that she left the station at 18:30 hours, having given the keys to the cells, and they are married to PW21. She said that she was given a lift from the post at 18:30 hours to Mlolongo, where she stayed until 2000 hours. Her witness, defense witness number 3 in his evidence, said that he picked the third accused at the post at 18:40 hours and dropped her at Mlolongo at 19:10 hours. Now, the third accused called defense witness number 4, Corporal Faith Motiso, who told the court that when she entered in the OB at the post that she had signed out of duty at 1700 hours, she did not see or she did not find the third accused at the report office. I consider the unsworn statement of the third accused. Her evidence was that she was on duty at the post those hours, 1600 and 1800, and that PW18, the third accused claimed she left at the post to hold her fort. In his evidence, between 1100 hours and 12:30 hours, denied having received such a request from the third accused. PW18 testified that he was on duty, the duty officer at Mlolongo police station, and that he was leaving the post for duty at around 12:30 hours when he met the second accused returning to the post. So the second accused admitted in his evidence that he met PW18 leaving the post as he returned at 12:30 hours. So the evidence of PW21 was that he found the second and the third accused at the post chatting away at 18:30 hours when he returned there from a 1 day's leave. He testified that the third accused gave him the keys to the cells and they are married between 7 and 7:30 p.m. That evidence is consistent with the third accused phone data. The evidence of defense witness number 3 that he picked the third accused outside the post at 16:40 hours is also not correct in terms of time. For defense witness number 4, her evidence contradicts the evidence of the third accused, saying that the third accused was not at the station at 5 p.m. Now, the prosecution has shown that the second accused was present at all the lock-in quo except for Kilimambogo. That is, that he was at Mavoko locals when the 3 deceased persons attended court. That he was at the railway line where the 3 were kidnapped at the time that it happened. That he arrived at Syokimau police post at the time when the 3 deceased were placed in the cells, and that the second accused was at Soweto open field where the deceased were murdered at the time that the murder was committed. Now, for the third accused, the prosecution has established that she was on duty as the report office personnel and the cell sentry when the 3 deceased were taken to the post. She had the responsibility over the key to the cells. Therefore, she must have opened the door for the deceased to be placed in the cells. She remained at the post from 10:09 in the morning up to 2000 hours in the evening, which period covered the time that the deceased were taken to the post to the time that they were removed from the post. I'm satisfied that the phone data of the second and the third accused was the true record of their movement and location on the whole of the 23rd of June 2016. That data clearly shows that the 2 played a part in the murder of the deceased. Now, the issue is whether the prosecution has established that the accused persons were principal offenders, acted with one common consent or intentional consent to commit the offense, and whether the circumstantial evidence adduced was sufficient to lead to a conclusion that the accused persons murdered the deceased persons. Now, I have begun with a quotation from a treatise of Samuel March Phillips, which I do not intend to read. Maybe I'll read a little bit so that you can hear what it is saying. It is a treatise on the law of evidence, 1824, for fourth edition, page 96 to 100, which opines, and I quote just in part, "It is an established rule that where several persons are proved to have combined together for the same illegal purpose, any act done by one of the party in pursuance of the original concerted plan and with the reference to the common object is in the contemplation of law, the act of the whole party, and therefore the proof of such act will be evidence against any of the other who are engaged in the same general conspiracy, without regard to the question where the prisoner is proved to have been concerned in the particular transaction." Now, Mr. Keegan submitted that due to the pecking order and that due to the junior rank of the third accused, she had no choice but to obey. He submitted that the third accused data shows that she did not communicate with the co-accused or the deceased and was not at any of the sites which was the scene of murder, and he relied on a case which is quoted there. He also urged that malice aforethought, as prescribed by Section 206 of the Penal Code, altogether is also incoherent. He urged that the second ingredient of murder, that is actus reus, was also not proved, that there was no evidence adduced to show that the third accused had anything to do with the murder of the deceased. Now, the prosecution proved that the third accused was at the post between 10:09 and 1900 hours, and that due to the opening between the cells and the report office at the post, the third accused must have seen the deceased in the cells. It was established that she was the sole officer on duty at the post, thus she was the responsible for the key to the cells and had custody of the station. Now, the submission by Mr. Ombeta and Mr. Keegan for the second and third accused respectively, that the phone data of their clients were in line with their defense, is not accurate. Their defense was in direct contradiction with their phone data, as shown here. The alibi defense the two put forth, as their defense was totally displaced, as the second accused phone data captured him at all the lock-in quo, and where the crime sites were located at the very relevant times that the events in question took place. The only place that the second accused was not located is the journey from Soweto open field to the Kilimambogo area. That means that the second accused was involved in the entire execution phase of the murder of the deceased, from the time that he proceeded to Mavoko locals all the way to the time that he proceeded to Soweto open fields and remained there until 8 p.m. when he switched off his phone. Now, for the third accused, she was at the Syokimau post continuously the entire day from 10:09 a.m. to past 7 p.m., which are the times the deceased were placed in the cells and later collected for the murder site. Now, Chapter 5 of the Penal Code is titled Parties to Offences, and Section 20 deals with the principal offenders. Now, in my considered view, given the fact that the third accused was the police officer manning the OB desk and also had the keys to the cells, where there was no entry in the occurrence book or in the cells entry or in the cells made to indicate that the deceased persons were held at the station, she was a principal offender. There is no way that the deceased would have entered the cells without her releasing the key to open it. She could not feign ignorance of the fact that the deceased persons were in the cells, as from the evidence of PW14 and PW39, her desk in the report office was at par with the opening between the report office and the cells. She was on duty continuously from 10:09 a.m. To 7:30 p.m. and present at the post all that time, as per her phone data. Being a police officer, the third accused knew the importance of keeping proper and up-to-date records at the post. It ought to have occurred to her that there was an illegal and wrongful intention to secretly detain the deceased at the post the moment no entry was made in the OB. So the third accused is a principal offender within the meaning of Section 21B and C of the Penal Code, and her position is similar to the ones who actually committed the murder against the three deceased. If the third accused had dissociated herself from the other co-accused by some action in order to show that she was not with them in the offense, then her role would have been different. However, she did not dissociate herself from the others. What she did was to deny knowledge of the incident. That does not exonerate her of these offenses. Now, I've considered that an accused person has a right to refuse to give self-incriminating evidence as set out under Article 52(1) of the Constitution. As a general rule, the burden of proof in criminal cases rests with the prosecution, and this is also as provided under Section 107 of the Evidence Act, which states that whoever desires a court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. Now, if it then follows that if an accused person chooses to hide some facts in order to protect others in court or at large, such an accused cannot be compelled to give such facts, since the burden lies with the prosecution to bring out such facts. The burden only shifts to the accused person under circumstances bringing into operation the provisions of Section 1111 and 119 of the Evidence Act. In this case, the burden shifted to the third accused to explain how the deceased were held at the post while she was on duty without any entry in the OB, how they were placed in the cells and later removed while she had custody of the keys to the cells. Instead of explaining these facts, the third accused decided to deny and also to mislead, feigning ignorance that the deceased were never there, as well as trying to escape culpability by implicating PWA 18 and 2021 as the ones with the keys at the time the deceased were taken to and removed from the post respectively. Even where the role played by the third accused was that of aiding and abetting, except for the change of terminology, at the end of the day, she is still a principal offender under Section 21B and C of the Penal Code. As for Mr. Gigan's submission that in regard to the pecking order, to obey orders to commit an offense is not a defense, certainly not to murder. It cannot be a defense available to the third accused. In the circumstances of the case, her role was critical, as it was possible for her to thwart the bad intentions of her co-accused just by entering in the OB, the placing of the deceased in the cells, and it was her responsibility to enter the OB if the ones who were expected to do so failed, as she was the one manning the post at the time. Now, for the second accused and the fifth accused, they were principal offenders by virtue of Section 21A, which provides that every person who actually does the act or makes the omission which constitutes the offense, the two of them took an active role in the kidnapping of the deceased, concealing their missing vehicle, detaining them without disclosure, ferrying them to the murder scene, and ferrying them around for each of these purposes. Now, the fifth accused in his statement stated that when they drove the deceased to Soweto open field, the co-conspirators argued for 3 hours whether to kill the deceased or not before they finally took their lives. The fact that they argued, then resolved to continue with their planned intention to take life does not reduce their actions to anything less than murder. They had a common intention within the meaning of Section 21 of the Penal Code, and I've quoted what it says. So for the second, third, and fifth accused persons, I am satisfied beyond any reasonable doubt that the prosecution has established that the accused persons were principal offenders. They acted with one common intention to commit the offenses charged as explained herein above. The evidence adduced by the prosecution against these three accused, which was largely circumstantial evidence, was sufficient to lead to a conclusion that the accused persons murdered the deceased persons. As to the alibi defense, the second and third accused person put forward, I am satisfied that as to the alibi defense, the second and third accused put forward, I am satisfied that it has not shaken the prosecution evidence that was adduced against them. Now, the other consideration is on the trajectory. This was PW37 was an officer based at the IC3, Inspector General's Office, Jogoo House, Nairobi. He testified that the IC3 is a center where all the 99 and 112 emergency numbers are received. He testified that the radio exhibit 25 was designed to give a location of its whereabouts. So he was given a request, which he said he now executed. He did a trajectory of the vehicles, which includes the vehicle that was carrying the deceased persons. And that I've already dealt with that, so I'll not go into that. Now, he testified that the investigating officers were also concerned to know whether any police radio phone registered activity within Mavoko locals, particularly in the hours of 1200 hours on 23rd of June 2016, and one radio fitted that description, which was the radio with ICDA number 359033304, which is exhibit 25. Now, PW37 stated that on further query of the serial number, it indicated that the radio phone was captured at Syokimau Police Post at 12:20 hours to 12:40 hours. The radio phone was captured at Mlolongo Police Station between 15:20 hours and 15:40. The radio phone was later captured again at 18:40 hours, between 18:40 hours and 1900 hours at Syokimau Police Post. The radio was captured at isolated field mastermind area called Soweto between 1940 hours and 2000 hours. At around midnight, the radio is captured on the eastern bypass traveling towards Kangundo Road. It was again captured at Thika Superhighway at 0040 hours, between 0040 hours and 1 o'clock on the 24th of June. This is the same night. And then finally on the 24th, the radio was captured at Valley View Estate between 22:20 hours and 22:40 hours. That radio phone, exhibit 25, according to PW20, the OCS Mlolongo, was IMEA number 864106020019873 and was issued to the in-charge SPIV, Senior Sergeant Leliman, who is the first accused in this case. PW20 testified that every radio has its own charger and that every office had a charger. PW20 testified that he issued the first accused with the radio, exhibit 25, which he received together with its charger. The first accused stated that upon deployment from Athi River Sub-County Headquarters in Mlolongo Police Station, following his transfer from Turkana to the region, his boss, who was defense witness number 10, Commissioner of Police, issued him with a firearm, a bulletproof jacket, and a radio phone. The first accused gave its number as police number 559030101 and the IMEA number 864106020310076 and was exhibit that 5. Now, the first accused stated that it was that radio phone that is he and his team used for their work. He explained that he could not have given this radio phone to anyone else except Sergeant Mwangi, as the other officers were from the regular police, that since the fourth accused was proceeding on short leave, he went home with the radio. That on the 23rd of June 2016, the radio was at home. And that on the 24th June 2016, he left the radio charging at Mlolongo Police Station, Crime Office, when upon switching it on in the morning of 24th, he realized that it had no charge. Mr. Ombeta submitted that the police should have investigated the alibi of defense of the accused, given it was put forward early enough. For that proposition, he relied on a Nigerian case. And then he also he relied on the Kenyan case, Wangombe versus Republic, for the proposition that a prisoner who puts forward an alibi as an answer to a charge does not thereby assume any burden of proving that answer. It is misdirection to refer any burden as resting on the prisoner. In such a case, for the burden of proving his guilt remains throughout on the prosecution. Now, the prosecution has established that on 1st July 2016, when the first accused was arrested, he had the radio phone, which is Exhibit 25. He also acknowledged in his defense evidence that he was actually arrested with that radio phone. As shown above in the evidence of that PW-7, this radio phone, that is Exhibit 25, was captured in all the sites at the various stages in the sequence of the commission of the murders. It was at the post at Syokimau, post at 12:20 to 12:40, when the deceased persons were delivered there and placed in the cells. It was captured again between 1840 and 1900 at the Syokimau post, the time the deceased persons were removed from the cells for Soweto open field. The radio was captured again between 1940 and 2000 hours at Soweto open field, where the murders took place. At around midnight, it was captured on the eastern bypass traveling towards Kangundo. The radio was captured at the Thika Superhighway at 040 hours, which is the time of the return trip from Oldonyo Sapuk. PW-7 testified that the phone radio signals could be tracked within Nairobi area and towards Thika. The signal tracking ends around Juja, which explains the lack of tracking beyond Juja, both for the trip towards and trip from Kilimambogo. Now, under Section 111, subsection 1 of the Evidence Act, the first accused to discharge a rebuttable presumption by offering a reasonable explanation about the radio phone Exhibit 29, which was tracked in all the lock-in quo, and 9 days later was actually found with him. I have considered the sworn testimony of the first accused. He stated that upon deployment from Athi River sub-county towards Mlolongo area police station, following his transfer from Turkana, his boss, who was PW-10, issued him with a firearm, bulletproof jacket, and a radio phone. Now, the first accused gave its number as police number 55903101 and a mare, which is Exhibit 35. Now, the first accused stated that it was that radio phone that he and his team used for their work. He explained that he could not have given this phone, radio phone, to anyone else except Sergeant Mwangi, as the other officers were from regular police. That since the fourth accused was proceeding on short leave, he went home with the phone. That on the 23rd, it was at his home. That on the 24th of June 2016, he left the radio phone charging at Mlolongo Police Station Crime Office. When upon switching it on, he found that it had no charge. That is on the morning of 24th. The first accused was arrested on the 1st of July, carrying the phone exhibit 25. When asked how come he had it, yet his evidence was that it was never used. Your exhibit that 5 charging in the office on the morning of 24th, and he proceeded to Makindu police station, but on the return he could not find it, so he grabbed the one that he found charging, which happened to be exhibit 25. Now what the first accused needed to give was a plausible and reasonable explanation of how he came to be found with P exhibit 25, which had been to all the lock and co of this case, and yet he insisted the radio phone was not the one that had been issued to his team. His explanation is incredible for reasons. One, PW34, the county commissioner, the county communications officer in Machakos, testified that on the 26th of April 2016, he issued new pocket phones to Athi River Division, which was to start using the new system of radios covering Nairobi area. His PW34 testified that he indicated who should receive which specific radios. In Mlolongo, he said the specific pocket phones that each officer, that is the OCS, his deputy, and his PIF team, and the CID section, and Syokimau police post were to be issued with, as per his register, which was exhibit 73A. 2. PW20, the OCS Mlolongo, confirmed that the first accused received the radio allocated to PIF team, which was exhibit 25. And then 3, the radio exhibit 36 had no data, and PW37 testified that the reason for no data was because it was never used at any one time. Indeed, PW44 and 45 and their team recovered it. At the time that they recovered it, it was in the house of the fourth accused. The radio was neatly packed in its box, complete with its wrappings and the nylon film used to protect the screen when it is new. It is therefore not true that the first accused, what the first accused said, that he and his PIF team used that gadget for their work. Now, 4, after being in each of the 5 sites or lock and co of the murders, the radio, which is exhibit 25, was captured at Valley View Estate between 22:20 and 22:40 hours on the night of 23rd and 24th June 2016. Now, Valley View Estate is where the first accused, the house of the first accused was. So where he lived with his family at the time. And then 5, the first accused was carrying the radio, exhibit 25, on the 1st of July 2016, when he was arrested at Flying Squad offices where he had been summoned. And lastly, since the first accused said that he was the one who had the radio, exhibit 36, on the morning of 24th of June 2016, when he left it charging in the office, how did it get to the house of the fourth accused? In its box, wrapped as new, complete with the protective film on the screen, and yet the fourth accused was away between the night of 22nd of June and 27th of June 2016. How did it get to the house of the fourth accused? Now, the evidence of the police radio phone trajectory detailing the movement of the radio P exhibit 25 on the 23rd of June, and the evidence of its recovery from the first accused 9 days later all show that the first accused, as in charge of SPIV and in line with the accountability protocol of accountable gadgets like police radio phones, had custody of the radio phone and had used it exclusively at all the 5 lock and co at the time the offenses were committed. The prosecution proved that the radio issued to the first accused by defense witness number 10 was never put to use. So I find that, as the radio indicated, the first accused was at the Mlolongo police station on the 23rd of June 2016. He proceeded to Mavoko Locals, then to Syokimau Post, to Soweto later that evening, where the deceased were all murdered, and to Klimambogo through Thika Superhighway to dump the bodies of the 3 deceased persons before returning to fetch his co-accused at his bar in Mlolongo for work well done. Now, I consider the first accused defense, the evidence of his witnesses. I find that the prosecution has established that it is the first accused who had the motive to harm the second deceased in this case, because as a result of the complaint he made against him at IPOA, his job was on the line. The first accused may have gone to Uhuru Camp to help his sister-in-law in the morning of the 23rd. However, from then on, the evidence is overwhelming that he personally attended to ensure that the deceased persons were captured, they were detained to await nightfall, they were murdered, and their bodies dumped or flung into the river to make it difficult to ever recover them. His explanation about the radiophone, Exhibit 25, just as his alibi defense, is unreasonable, incredible, and is not plausible, and therefore I reject it in total. I have carefully considered the entire evidence adduced in this case by both sides, and I have considered the submissions by counsel, the authorities relied upon, and having done so, I find that the circumstantial evidence established against the first, second, third, and fifth accused persons justify the drawing of an inference of guilt to the exclusion of any other reasonable hypothesis except that of guilt. I considered whether there were coexisting circumstances that could weaken the chain of the circumstances relied upon, and found none. I am satisfied that there was no other reasonable hypothesis that can be made on the basis of the evidence before me except that of guilt. In the result, I find that for the fourth accused, his alibi defense has shaken the veracity of the evidence of the prosecution against him, being that of the fifth accused alone, and therefore I gave him the benefit of the doubt and acquit him of all the 3 counts of murder under Section 322 of the Criminal Procedure Code. For the first, second, third, and fifth accused, I am satisfied the prosecution has proved the case against them beyond any reasonable doubt, and therefore I found them guilty of the 3 counts of murder, contrary to Section 203 of the Penal Code. I accordingly reject their defenses, find them guilty as charged, and convict them accordingly under Section 322 of the Criminal Procedure Code. Now, I also want to inform the first, second, third, and the fifth accused persons that they have a right of appeal within 14 days from today. And before I end, 2 things. I wish to register my gratitude to the Learned Prosecution Counsel, the Learned Counsels for the defense, and the Learned Counsels for the victims and the interested parties. And I thank you very much for your great support, your industry, and contribution to jurisprudence, and also for giving me an opportunity to complete this case. And I also thank the accused persons for allowing me to complete the case. At the beginning, it didn't look like it was going to happen. Now, I wish to end with a little story. There is a man who told his son that he wanted to teach him a new trade, so he asked him to follow him. They went to the neighbor's farm and stood next to a mango tree. The father told the son to look around as he climbed up to pluck some mangoes. He told him that his role was to look around, and if he saw anyone at all, to start running home, and his father would follow him to avoid arrest. So the young old man climbed the tree. After 5 or so minutes, the father saw his son running, so he climbed down quickly and followed him. After running for some time, And seeing no one following them, the father stopped his son and asked him why he ran, telling him that he did not follow his instructions. So the son said, "No, but I did follow your instructions. I looked up and I saw God looking down on us, so I ran away." So that is the end. Now,
before sentencing, they should be on record.
now I'm totally funked as official. I want to make only one order. To take this, to have this file placed before the presiding judge criminal, so that you proceed with the other things. What did you want to say?
Obviously, before the sentencing, we wanted to inform the court that the four accused persons are first offenders.
No.
But we'll do it for the other court.
Not even that. I think we also need to have victim statements,
yes,
victim impact statements and things like that.
And of course, we wanted to request whether there can be also completion of such a report before the sentencing.
Tell them to stand.
Your Ladyship, we requested we have an issue that you raised. Your Ladyship has said that your predisposition is that the other aspects, including sentencing, should go probably to another judge. On behalf of the third accused, Your Ladyship, we would have preferred that you complete the process. Yes, we want to be on record as saying that, Your Ladyship.
I thought you said I'm coram non judice.
I think I'll be taking the same position with my colleague, because again, also having had your judgment and another judge coming in to give the sentence, putting into consideration that you said the second accused person gave unsworn evidence, yet we know clearly that he gave sworn evidence. How would that be handled? He gave sworn evidence, he was cross-examined. In your ruling, the whole judgment is that he gave an unsworn statement. From this particular point onwards, you can see why we want to appeal and why we're having a problem with the judgment.
I don't know what you are saying. What are you saying? Are you saying I hear this, I do the sentence, or are you saying?
Yes, you let us go to the end, because you see, the moment you have said that my client gave unsworn evidence, yet we all know that he gave sworn evidence and was cross-examined. That puts us in a position whereby, first of all, we are saying that probably the new judge who comes in to do the sentencing must look at that as well. You having then given the judgment with this very serious omission or problem that you have created, do you shift this burden to another judge, or do you do it by yourself? Because for me, it is pretty serious that you did then not get the evidence of a second accused person you have convicted him, yet he gives sworn evidence. It was cross-examined by everybody, but according to your record, it was unsworn. How did this come about? So these are issues that we will raise, probably maybe even in the next judge, but I'd rather that you are there so that we can throw these rocks at you.
Your Ladyship, the honor here was mine. I just want to dissociate myself from what Cliff has said, Your Ladyship. Your Ladyship, My point is this, Your Ladyship. I'm not taking the same militant position as Cliff is taking. My point is this, Your Ladyship. Sentencing is the point at which a judge is most subjective. It is the point at which the judge is applying consideration of all the issues that are obtained since the start of the case. And for that reason, Your Ladyship, if there was any role you would have played, it is more at sentencing than at any other point. And for that reason, Your Ladyship, I'm making more informal request, Your Ladyship, that you do, having come this far, that you do entertain the process up to the point of sentencing.
No, but somebody wants to throw things at me, so why do I want to sit around to wait for missiles to be thrown?
Who else can we do that? You see?
Now I think, let's hear Mr. Michuki.
Yes, because even when you place the radio in the second accused hands and you read it in your judgment, we have a problem, don't we?
Your Ladyship, just 2 points. First, I'd like to associate myself with my senior, Mr. Carter. I think sentencing is an exercise of discretion, which you have to take a number of factors in. A new judge does not have a grasp of this matter to every sentence the accused person or not the convicted person. Secondly, my lady regards to the seeking indulgence that he continues being held as Naivasha under the protective circumstances. He has been held since he took play in this matter. Yes, separating from the other accused persons has always been the case. Lastly, off the record, given that my remuneration falls squarely upon you, my lady, I would wish for you to proceed.
I thought you are the one who is very sure I'm quorum non-judice.
Your lady, you already assumed jurisdiction. I will follow you. I'll follow your decision. We cannot give any other issues on appeal.
Your Ladyship, on behalf of the court accused, we can only say thank you. It has been a long journey.
My lady, on behalf of LSK and the victims in Soweto, Mr. Chairman.
As well, on behalf of yes, on behalf of the court accused, we are also requesting that his mobile phone unit has been found, be restored to him. And also, on behalf of the pastor accused, only for Plan and Council, Mr. Cliff on better, is requesting that his car be released.
Whose car?
The first accused.
There was a motor vehicle that was used as an exhibit that was detained. We had that argument and the state had said that they wanted to vote on it. You had made a decision that you would, at the end of the trial, make a decision about it. There was a motor vehicle that was used as an exhibit. It was KT 959 something. So long we have not forgotten about the number plate. But it's in the court.
I don't know what I'm releasing. Does it have an exhibit number?
I know it's a KBF 959H. It was a Winroad Nissan. KCG 959H. It was a Nissan Winroad white in color. No, second color.
That's not the one you released to the wife of the first accused. It's not the one.
Nothing was released.
K what?
KCG 959H.
Yes. Anyone else?
Really, on behalf of the victims in their entirety,
Yes, just 1 minute. Just 1
the
minute.
family and advice, we would also wish to file a victim impact assessment 339C of the CPC. And we are seeking 14 days and victims in their entirety.
So when you say law society, how many statements am I going to get? Or will be filed? You are saying the entire law society, so I don't know how many statements.
It will be just 2 statements, but covering the victims in their entirety. Let's say victims in terms of the family.
Yeah, because I wanted to adjourn, but other people have now said other things.
Yes, now that we proceeded, allow me to say this. First of all, that the 4 accused persons, 1, 2, 3, and the 5th, we have no previous records of conviction.
We are not taking any mitigation at this stage.
Okay, I'll say that later. Then, really, my view is that a court that convicts is the most appropriate sentence. And we require 2 weeks to have the statement. That is the last statement. We have found only 3 in relation to the deceased persons. Put in place for your consideration. We also urge you to exercise your discretion and order for progression of Gaza report in respect of the 3 accused persons to be filed and shared with the prosecution before the sentence is closed. These are our 2 prayers. The issue has been raised by a motor vehicle, which was produced by the prosecution, which belonged to the spouse of the first accused. And the motor vehicle that was used to carry the deceased person's bodies to the family. We have not come to the conclusion of this matter. We only have a conviction, and it will be premature. My understanding and the interpretation of the law to come to this matter now. But when we come to it, the way we want to address
myself substantially, because as you indicated when there was an attempt with the use of the motor vehicle, we did indicate that this was an instrument of crime which is subject to oppression, which are auxiliary orders of court. So I don't want to go into it.
You're saying subject of what?
Oppression. And I don't want to go into this because we want after the conclusion of this matter to address the issues substance where we have. And if need be, we file our submissions in the matter in the respect of the release. That is all we have. In this motor vehicle, we had a problem about it. Initially, at the close of the prosecution case, and then after the defense case, and now a creation is being made that is subject to forfeiture. That does not exist on any law.
No, I'm not.
The only thing that exists on forfeiture is known. It's either things to do with drugs and lots of things. In other cases, let's not create this law. It's not there. Let him just release the motor vehicle. I don't know what interest they have on this motor vehicle on the 3 stages that we made this application. It does not exist. If it does not exist, then your leadership can't even give you time to make an application about it. It doesn't exist.
No, I will not consider that one for now. I think if their indication is they want to make submissions, then we can hear, but both sides can be heard. Yes.
Your Leadership, I just wanted to seek a copy of the judgment of the court for now. To go on record that we get it proposed. Your Leadership, the monitoring and the proceedings certified for purposes of appeal.
The proceedings are there. I thought you have been getting all of them.
They're not certified, Your Leadership.
And now I'm funked as official. You will talk to the DR. So is this?
Your Ladyship, we have a request also for the third accused. Your Ladyship, in view of what the prosecution has said and the victims, Your Ladyship, we would pray that the victim impact reports, Your Ladyship, be designed in a way to make reference to specific accused persons, Your Ladyship, rather than general quotation on the part of the victim's Ladyship. And we still plead with you not to step out, Your Ladyship.
No, I think I've had enough. I should just step out of this matter. Don't you think?